You guys good to go then? Committee will come to order without objection. The chair is authorized to declare recess at any time pursuant to Committee Rule 2, House Rule 11, Clause 2. The chairman may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote is ordered. And now recognize the gentleman from Arizona to lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you, gentlemen. Pursuant to notice, I call up H.R. 354, the LEOSA Reform Act, for purposes of markup, and move the committee reported favorably to the House. The clerk will report the bill.
H.R. 354.
Without objection, the bill be considered as read and open for amendment at any point. The chair now recognizes himself for an opening statement. H.R. 354, the LEOSA Reform Act allows qualified active and retired law enforcement officers to carry a concealed firearm in national parks, school zones, public transportation, and in some federal facilities that are open to the public. LEOSA was initially signed into law by President George W. Bush in 2004 to exempt certain active and retired law enforcement officers carrying a LEOSA photograph identification card from local and state prohibitions on the carrying of concealed firearms. In order to qualify under this legislation, active law enforcement officers must meet several requirements. For example, they must be authorized to carry a firearm by their agency. They can't be subject to disciplinary actions by the agency that could result in a loss of their police power. They have to meet certain firearms proficiency standards. They can't be under the influence of alcohol or other intoxicating substance, and they must not be prohibited by federal law from receiving a firearm. Retired law enforcement officers must also meet a number of requirements in order to qualify. For example, they must have separated from service in good standing and served as a law enforcement officer for an aggregate of 10 years or more. They're also required to meet certain firearms training standards and must not be prohibited by federal law from receiving a firearm. This act will allow these officers to carry a concealed firearm in the same manner that many licensed citizens carry a firearm in their state. For example, the LEOSA Reform Act will allow qualified active or former law enforcement officers to carry concealed firearms in national parks, federal facilities that are open to the public, and other transportation in school zones and in other areas. The bill also reduces the frequency that qualified retired law enforcement officers are required to obtain certain qualification standards. Many states allow state-licensed concealed carry permit holders to carry a concealed firearm in gun-free school zones and on public transportation in the state in which they are licensed. This bill affords certain law enforcement officers the same privilege. We must support our active and retired law enforcement officers and ensure that they have the ability to protect themselves and others, no matter where they are in the United States. This legislation is supported by the Fraternal Order of Police, the Federal Law Enforcement Officers Association, the National Association of Police Organizations, Major Cities Chief Association, Major County Sheriffs of America, and the National Organization of Black Law Enforcement Executives, and many others. I urge my colleagues to support this bill and yield back. Chair now recognizes the ranking member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, the LEOSA Reform Act would remove critical gun safety protections from the Law Enforcement Officer Safety Act, or LEOSA, which became law in 2004. To understand just how problematic this bill is, it is helpful to revisit a little bit of history from the committee's past. Under a Republican majority, the committee report on LEOSA began by explaining that, quote, a state has traditionally, in the exercise of its sovereignty, controlled who within its borders may carry concealed weapons and when law enforcement officers may carry firearms, close quote. The report explained that LEOSA would override virtually all state laws on concealed carry. It would supplant the judgment of the states about the appropriate use of firearms by off-duty and retired law enforcement, both for their own agencies and for the law enforcement agencies of every other state, and would force states to allow these individuals to carry concealed firearms within their borders. The Republican chairman of the committee at the time, Jim Sensenbrenner, began the markup of the bill by saying, quote, it is no secret that I am opposed to this legislation. I believe it violates the principles of federalism and undermines the authorities of the states. This legislation would disregard the judgment of state authorities on what many believe is an important public safety issue, close quote. I agreed with those sentiments, and we both opposed the legislation. I also explained that the bill created the problem by allowing nationwide concealed carry by off-duty and retired law enforcement without any national standard for training. New York City could require one level of training, while a small rural city with very different needs and a very different approach to policing could require a very different level of training. And yet each would be forced to allow the others off-duty and retired officers to carry concealed firearms within their community and potentially even in interactions with their own on-duty law enforcement. The International Association of Chiefs of Police, or IACP, opposed this legislation too because they were concerned about how it could endanger law enforcement and could lead to situations in which officers from one jurisdiction are killed or injured by local police who cannot distinguish between a criminal and a retired officer using a firearm. The Police Executive Research Forum, or PERF, opposed the bill because it could put police agencies at risk for liability for an officer who misuses a weapon in another state, and because the requirements for retired officers were insufficient. For all of these reasons, I joined former Chairman Sensenbrenner and other members from both sides of the aisle in opposing LEOSA. Unfortunately, it became law despite our objections. Importantly, the law included exceptions for special places like government buildings, gun-free school zones, and private property. These exceptions have been in place for 20 years and have served as important protections. But this bill tosses those exceptions out the window. This bill eviscerates the rights of states to control the concealed carrying of weapons, even in places where a state has a special interest in retaining control of its gun safety laws and where Congress has protected that interest for 20 years. It forces states to allow off-duty and retired officers to carry firearms on playgrounds, government buildings, and on buses, trains, subways, and boats. It reduces the rights of private property owners, including individuals and organizations who may not want concealed weapons on their property. It undermines state laws limiting magazine capacity by allowing some people to carry large capacity magazines even when a state has prohibited them. It relaxes training standards so that some people will be able to carry a concealed firearm even though it has been 3 years since their last firearms training certification. Not only does this bill infringe on the rights of states and private property owners, but it also unravels federal laws that have kept firearms out of federal facilities. It does this for federal facilities that are open to the public, in quotes, and that are classified as, quote, facility security level 1 or 2, close quote. This definition will create significant confusion for those trying to abide by it and for those tasked with enforcing it. If a federal facility is only partially open to the public, or only open to the public during certain hours, does it fall within the bill's definition? We don't know. What about a facility that is open to the public so long as they are not carrying firearms? The bill does not say. And as the bill itself states, the facility security level is determined on a facility-by-facility basis and may not be publicly posted. So it is virtually impossible to know what federal facilities are included in this definition. We looked for a listing of federal facilities that are classified at these security levels, and we could not find one. Members may even have offices in federal facilities that will suddenly be forced to allow concealed firearms in their doors as a result of this legislation. I was proud to join my Republican colleague, former Chairman Sensenbrenner, in opposing the original LEOSA. He recognized that it undermines states' careful determinations on how best to protect their citizens from gun violence. This bill is an even further intrusion on their ability to make their own judgments about public safety, concealed firearms, and the regulation of their own law enforcement. For all these reasons, I urge my colleagues to join me in opposing this misguided and poorly crafted legislation, and I yield back the balance of my time.
Without objection, all other opening statements will be included in the record. The chair now recognizes himself to offer an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of amendment. Chair now recognizes himself to explain the amendment. This amendment makes a small change to the short title of the bill and does not affect the substance of the bill. Who seeks recognition?
Mr. Chairman.
Gentleman from Arizona, and then we'll go to Mr. Ivey.
Move straight to the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. So with the active efforts to eradicate the Second Amendment, I'm for any pushback against that movement. Here, we are granting recognition of rights to carry weapons of highly trained police officers. I have a hope that that would be extended to all citizens as well, that we would further acknowledge our God-given constitutional rights. That's really what this issue is for me. I'm for any measure that will restore the Second Amendment and will move to do that. It may not be the full measure that I would like to see, but this is another step along the way to accomplish that, and I think that's a righteous task, and I'm going to be supporting this. Yield back.
Gentleman yields back. The gentleman from Maryland is recognized.
Thank you, Mr. Chairman. I have a few questions about the bill, and I guess you are the author of this amendment, Mr. Chairman?
Mr. Bacon, this is Representative Bacon's legislation.
Okay. Can I direct questions to you then?
You can direct them here, and I'll attempt to respond.
Okay.
Or we'll go to one of our members.
So on page 5 of the ANS, there is a reference to the biannually issued Interagency Security Committee standard. And this standard apparently helps determine what federal facilities are included and which ones are not. We were taking a look at what, as far as we could figure out, what that reference is, but I'm unclear as to what it is. Could you give me some guidance on that?
My understanding is DHS, Federal Protective Services, works to establish the level of risk at these facilities. I'm trying to read.
Well, the reason I ask, and I appreciate the fact this isn't your amendment, and I'm not trying to put anyone on the spot, but the underlying statute that is amended, the current law, speaks in terms of federal facility. So D3, the lawful carrying of firearms or other dangerous weapons in a federal facility incident to hunting or other lawful purposes, or 2, possession of a firearm or other dangerous weapon by a federal official or member of the armed forces if such possession is authorized by law. So I'm wondering if your amendment actually restricts in some way what federal facilities are being covered. You understand what I'm asking?
Excuse me, not exactly, but I don't think it does. I think it actually may go, I don't think it restricts. If anything, it may expand. But
I'm sure it was intended to expand.
Right.
But but the language that you got would add a paragraph 4 in section D. And so it doesn't change the language above, but it does put in a new standard with respect to not only the qualified retirement law enforcement officers, which I think is the point of the amendment, but before that, qualified law enforcement officers, which is what I thought was being,
I'm not sure where
is already permitted.
Tell me exactly where. Are you on page? I want to make sure I'm at the right section.
I am on this section, this version.
No, I got the version. I'm just talking. Which section are you?
This is the last page of your actual language. So this would be
Page 5 of the bill. Still.
Yes, sir.
Okay.
And so paragraph 4, in particular, at the top of page 5, and then below that, there's a definition for federal security level, which references the Interagency Security Committee standard.
Right, which is DHS. Okay.
Okay, and you told me what you
Right.
think the Interagency Security Committee standard is, although I'm frankly still unclear about that. But back up to top of page 5, under section 4, line 3, qualified law enforcement officer, I'm asking about now. Because under the current law, it doesn't speak in those terms. It talks about lawful performance of official duties by an officer, agent, or employee of the United States. That's D1. D2, possession of a firearm by a federal official or a member of the armed forces. And so I'm not clear about the purpose of changing these definitions or the impact that it has. I'm running out of time.
No, I understand. They're currently not allowed to carry in these facilities. This legislation would permit qualified law enforcement officer to be able to carry in these facilities. That's what it does.
Okay, but it creates conflicting definitions, number one. And number two, with respect to the definition of what a qualified law enforcement officer is. But number two, I don't know what new federal facilities would or would not be permitted under the Interagency Security Committee standard as we looked it up. So, I wouldn't necessarily object to having conversations afterwards with perhaps the author to try and figure it out. But as it stands now, I'm going to move to strike it because I don't know what it does. So I'm not offering the amendment yet, but I do want to raise that. And I yield back. Well, I don't have any time to yield back, but I thank the chair.
That's fine. Gentleman yields back. Gentleman from Kentucky is recognized.
Mr. Chairman, I'm going to support this bill, but reluctantly so. I mean, we should not just extend these or acknowledge these rights for law enforcement officers. Every individual in America who's not a criminal should be afforded these rights. Gun-free zones make people less safe. They just advertise sitting ducks. That's what the Gun-Free School Zone Act does. It was passed in the 90s, and it hasn't made kids safer at all. In fact, it's made them less safe, and it creates this conflicting patchwork of laws where the default situation is that law-abiding citizens are criminals just for getting near a school. So I think this bill actually doesn't go far enough. I've supported legislation, written and introduced legislation to end the Gun-Free School Zone Act, which, by the way, was ruled unconstitutional at one point. And then it was rewritten by Congress and reintroduced. I think it's still unconstitutional. But I've also sponsored legislation, or at least voted for legislation, to get rid of the gun-free zones in national parks. Why should somebody who's visiting land that is owned by the taxpayer give up their constitutional rights just simply to visit a park? Are we making anybody more safe by saying you can't carry a firearm, you can't exercise your God-given right to defend yourself in a national park? It seems ridiculous. It should be the other way around. If this is a national park and the Second Amendment applies nationally, then that is the one place where you shouldn't be prohibited. All places you shouldn't be prohibited, but that is specifically one of the places that the Second Amendment should apply to. And furthermore, we had the 2008 Supreme Court case which was D.C. versus Heller, that said that the Second Amendment doesn't just apply to the National Guard, for instance, it applies to all Americans. That is what the 2008 Heller decision said. And then in 2010, the McDonald versus Chicago extended that to apply to all the states through the incorporation doctrine. So the Second Amendment is actually a restriction just not on the federal government, but also on the states. They can't infringe on your Second Amendment rights. So, I support the bill, but the problem is, here we are carving out special rights for people that carry a badge, when in fact these are rights that were enshrined, protected, given to us by God, but protected by our founding fathers in the Constitution, a document that we've sworn an oath to defend and uphold. So I will just close by saying I'll support the bill, but we need legislation that goes further to state what is inherent in the Constitution. I yield back.
Mr. Chairman.
Gentleman yields back. The ranking member is recognized.
Thank you, Mr. Chairman. Mr. Chairman, I already commented on this bill, and I'm not going to further comment on the merits of the bill. I do want to comment on what Mr. Massey just said. The Second Amendment reads, quote, a well-regulated militia being necessary for the security of a free state, comma, the right to bear arms shall not be infringed. It is clearly a right. The founding fathers, the framers, were opposed to standing armies. They thought that those were instruments of tyranny and that a militia is what should be had. And the Second Amendment was a guarantee, was framed as a guarantee that you could have a militia, a well-regulated militia being necessary for the security of the free state. And that was its understanding for 200 years until the radical Supreme Court in the Heller decision upended 200 years of constitutional interpretation and said that the Second Amendment has nothing to do with militias. It's a personal and basically unlimited right. The Supreme Court was wrong in that decision. It has made the country much more dangerous. The United States is the only country in the world where you see mass shootings in schools. We're told that that's because of mental health, but I do not believe that the American people are 75 times rather more mentally ill than people in Germany or Britain or Canada. But we have 75 times more school shootings. I do believe that one of these days we'll have an intelligent Supreme Court and we'll get back to the historical understanding of the Second Amendment, and that will be a blessing for everyone in this country. I yield back.
Gentleman yields back. Gentleman from North Dakota is recognized.
Thank you, Mr. Chairman. Move to strike the last word.
Gentleman's recognized.
Yeah, that functionally is why we're here. What we're doing is the comma matters. Actually, both commas in the Second Amendment matter. Heller spent an exorbitant amount of time discussing that, going through where it was. And I reject the premise that up until the Heller decision, the only people that were allowed to keep the absolute right to keep and bear arms were militias, because I've had that right my entire life. Heller came out significantly before that, or significantly after that. And I come from a very pro-Second Amendment state. Pretty sure my right to keep and bear my Benelli shotgun or my Ruger #1 rifle isn't associated with my membership in a militia because I'm not in one.
Would the gentleman yield?
Yeah.
I just want to comment, of course you had that right, but those rights that you and many other people had were in accordance with state law. The question is, do the states have the right to regulate? And that's what I was talking about.
Absolutely. And I mean, we can discuss whether we think the Heller decision was right or wrong. I obviously 100% agree with the Heller decision because I understand the history of how the United States started, where we were at, what we were doing. And I also just find it massively, massively interesting that we don't apply the Second Amendment in the same, or the First Amendment in the same way we apply the Second Amendment. They're right next to each other in the Bill of Rights. You can't have the most narrow possible reading of the Second Amendment and the most broad reading of the First Amendment. Because if we did that, if we applied the Second Amendment analysis that a lot of my colleagues on the other side of the aisle would like to apply, and we applied that to the First Amendment, the only thing that would be protected were printing presses. Like, you can't have a different analysis of two amendments in the Bill of Rights that are right next to each other. You either have to agree that they adapt and modify to common times, or they don't. But you can't say the Second Amendment doesn't adapt to modern times, but the First Amendment does. And that is functionally what we have done, and we continue to do in this process. And it's fascinatingly intellectually dishonest, it's legally dishonest, and we have to continue to move forward with that. But the reality of the situation, as we sit here today, Heller is the law of the land. It upholds the United States, the Second Amendment, as most of, if not all of my colleagues on the Republican side agree, and this is good legislation, and I actually agree with my friend, Representative Massey, that I wish it went further, but the least we could do is allow people who have been trained, who have done this, who have spent their entire life protecting our communities, and we ask them to go out with a gun on their hip every day. And remember this, the only time you know a routine traffic stop is routine is after it's over. And then all of a sudden, if they're off duty or retired, we're saying, thanks for playing, here's your gold watch, but you no longer can do what you have done for the last 30 years, and that's protect communities. I am yielding to my friend, Massey.
I think, Mr. Armstrong, for yielding, look, 96% of mass public shootings happen in what's called a gun-free zone or a jurisdiction where individuals are not allowed or permitted to carry a gun. And that is because criminals do not obey the law. That sign does not protect you if it's at a national park or a school that says this is a gun-free zone, simply because the criminals look at that and they just walk by it. In fact, they may look for that. There's evidence that mass public shooters in their manifestos that oftentimes people try to keep suppressed because they don't want to know what's going through the mind of these deranged criminals. But what's going through the mind of these deranged criminals is they are looking for the weakest target possible. And so they're going to seek out these gun-free zones. And so I do support allowing carry in the gun-free zones and support our law enforcement officers who should be allowed. If we're not going to allow people to protect themselves in a gun-free zone like a national park, then we sure as hell better let the law enforcement officers who've had the training to protect those people, because the criminals are going to carry in those zones, as we've seen 96% of the time. And I yield back to the gentleman, Mr. Armstrong.
Will the gentleman yield?
I've got 27 seconds, and I would just also really quickly like to point out that you can't have guns as created in the metric that we have, which is interstate commerce by its very nature, and allow for federal litigation on liability of gun owners and manufacturers and all of those things, and then say, but states are allowed to regulate them in the most restrictive way possible. But if we're going to deal with it in any sense of the other side of the liability issue, we're going to make it all federal. So with that, I yield back.
Gentleman yields back. I would just say we heard this last Friday in Philadelphia from the father of a son who was a law enforcement officer who was killed by a gang member. Dr. Fitzgerald said, to Mr. Massey's point, bad guys aren't stupid, they're just bad. And they know the law. They know what's going on. They know that, if you're not allowed to carry in a certain area, going to be tough for the people they're trying to target for a crime to defend themselves. And so that's sort of the premise of this idea, particularly now when we're talking about people who've been trained, retired law enforcement officers, to be able to carry a concealed firearm in those respective areas. But Dr. Fitzgerald was very clear about that. I'll yield to the gentleman from Maryland because I know he wants more time.
Thank you, Mr. Chairman. I appreciate that. I just want to bring this back to the actual language in the bill and actually in Heller, because in Heller, the court explicitly carved out certain exceptions, including, government facilities. And so I don't know about the parks and things like that, but this speaks to federal facilities like this building, for example, and whether we could have, if I'm hearing you all right, you'd like to get rid of the metal detectors that are in front and checking people as they come into Rayburn or the Supreme Court or even the White House.
I don't think anyone said
even
that.
The Supreme Court didn't go that far with Heller or Bruin, although I suppose they could, depending on what new Bruin rulings come. But the only point here, I think, is, whether we should be allowing, well, my only question was what this language actually does. And it only deals with federal facilities. As I read it, it's speaking about buildings like this one, not parks or schools or anything else like that. But if that's incorrect, I stand corrected, or and let me know. But with that, I yield back.
Would the gentleman from Ohio yield?
Happy to yield to the gentleman from Kentucky.
Apologies to Ranking Member Nadler if this isn't what he stated, but I think he might have left out some key words when he read the Second Amendment. And I'll read it here. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And I'm not sure if I heard him say the people, which applies to all of the people, as we well know. And I yield back.
Gentleman yields back. Does the gentleman want more time? Oh, no, we can come to that, I think. We'll do that. Chair yields back. The gentleman who seeks recognition, the gentleman from Maryland is offered for an amendment.
I have an amendment at the desk.
Clerk will report. Gentleman from Arizona reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 354.
Without objection, the amendment be considered as read. The gentleman from Maryland is recognized on his amendment.
Thank you, Mr. Chairman. Basically, as I mentioned a moment ago, the logic here is to strike Section 4 of the the ANS. So that begins on page 4, line 14, and goes through to the end of the ANS to page 5, line 15. And as I mentioned before, I'm moving to strike here for a variety of reasons. The biggest one, though, is I don't really know what this does. And I'm not clear. I don't think it's been explained clearly about what it does. And I don't think it offers clear guidance. I would be open to scenarios where officers are allowed to carry guns, or retired officers are allowed to carry guns. And I'll say this, when I practiced in federal court, this standard kind of applied. Now, the courts that I was in, at least, required the officers to check their guns, so they didn't walk around in the building with their, concealed carry on. They didn't have the gun on themselves when they walked into courtrooms or wherever they were going. But, it was permitted. So I take that point, but I'm not sure what this would do. I don't know if this changes that particularly or not. And again, I don't understand what the Interagency Security Committee standard is. We can't figure out what facilities are specifically covered by that, which I think is significant to know, because if it's unclear, the flip side of this is you could have a retired officer walk into a federal court building thinking it's okay, and then finding out that it's not, and finding out the hard way. And I don't think anybody wants that. So I'm offering this, if the committee wants to move forward with this language, I think it's important to move to strike it now. We can revise it. It may or may not reach common ground, I don't know. But as it stands right now, I think it's unclear, and the risk that it creates for retired officers or even active duty officers, I don't think is where any of us want to go. And with that, I yield back.
Gentleman is back. The gentleman withdraws his, gentleman from Arizona withdraws his point of order. I would just say, under current law, the only way a law enforcement officer can enter a Social Security building or Veterans Affairs office or post, only way he can enter those buildings is if he's on a call. He's been called there to, an active call for service. The bill allows current law enforcement and retired law enforcement who meet all the qualifications in the legislation to actually go into those facilities. Now, they still have to follow whatever rules to come in. There's a metal detector, they still have to do that. We all have seen that, but that's what the legislation does. And I would oppose the amendment.
Would the chairman yield for just a moment?
Sure.
So I'll give you a scenario. So when I was initially practicing in Washington, D.C. in the early 90s, the local jurisdiction had a law in place, and it's quasi-federal because it's the District of Columbia, but you could have an officer on vacation coming to visit the Capitol with his family, and he would walk up to security and say, hey, I've got my service weapon on me, and he would get arrested, okay, because it was a violation of the law as it stood then. And the scenario I'm trying to say we don't want is obviously that officer didn't realize that it was illegal for him to carry the gun at that time. He would have left it wherever he, trunk or whatever. I don't want the modern day version of that to happen, right? And so I'm concerned that the way this language is written could create other problems along those lines, because it's not straightforward to me. I can't figure out what it says. So that's the concern. Now yield back, and I thank the chair for yielding.
No, fair enough. Obviously, the Capitol's different. We're under different Capitol Hill Police, different jurisdiction, but in the example you used. But we're talking about other federal buildings, and we can look at this and make sure before this goes to the floor. But what I'd like to do is pass the legislation without the amendment. And if there is a real concern there, we'll be happy to work with you as before this bill goes to the floor. But it's probably heading to the floor next week.
Well, I'll ask for the vote on my amendment. I appreciate the chairman's decision there, but I would ask for the vote.
I understand.
In any event.
I understand.
Thank you.
Who seeks recognition? Question occurs on the amendment from the gentleman from Maryland. All those in favor say aye.
Aye.
Those opposed, no. No. In the opinion of the chairs, the noes have it.
Roll call.
Roll call being requested, the clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Isa? Mr. Gates? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Sparks? Mr. Fitzgerald? Mr. Bentz? Mr. Klein? Mr. Armstrong? Mr. Armstrong votes no. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Nels votes no. Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Mr. Moran? Mr. Moran votes no. Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy?
Aye.
Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye.
Gentleman from Wisconsin.
Mr. Fitzgerald votes no.
How's Massey recorded?
Mr. Massey, you're not recorded.
I vote no.
Mr. Massey votes no.
Clerk will report.
Mr. Chairman, there are 7 ayes and 13 noes.
The amendment is not adopted. Who seeks recognition? Question occurs. Questions on the adoption of the amendment in the nature of a substitute. This will be.
Chairman, there's a unanimous consent request.
Okay.
I believe the chairman referred to the murder of Sergeant Christopher Fitzgerald as a gang member. That is not correct. The alleged killer, Miles Pfeffer, had no known connection to a gang. He was an 18-year-old from Bucks County, a rural area outside of Philadelphia, who had access to numerous firearms in his parents' homes. His parents did not secure these firearms despite his signs of dangerousness. His mother picked him up after the killing. I ask unanimous consent to submit to the record this article from Fox 29, Philadelphia.
Yeah,
Family of slain Temple University officer Sergeant Fitzgerald files civil lawsuit against alleged killer's parents.
Without objection, I apologize. I made a mistake on, we talked about gangs at the hearing, and I thought that was the case with him, but I obviously mistaken. Without objection, that will be entered into the record. That doesn't change the fact that Dr. Fitzgerald said bad guys aren't necessarily stupid. They're just really bad. Okay, the question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no.
No.
Depending on the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. Wait, I got to go to the next one. Reporting quorum being present, the question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no.
No.
Opinion of the chair, the ayes have it.
Now roll call.
Roll call being requested. Clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Isa? Mr. Isa votes yes. Mr. Gates? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey?
Aye.
Mr. Massey votes aye. Mr. Roy? Mr. Bishop? Mr. Bishop votes aye. Ms. Sparks? Mr. Fitzgerald? Mr. Bentz? Mr. Klein? Mr. Armstrong? Mr. Armstrong votes yes. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Mr. Moran? Mr. Moran votes yes. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes yes. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes no. Ms. Escobar? Ms. Escobar votes no. Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Ivy? Mr. Ivy votes no. Ms. Ballant? Ms. Ballant votes no.
Gentleman from Wisconsin.
Mr. Fitzgerald votes aye. Ms. Sparts votes yes.
Gentleman from California. Gentleman from California.
Mr. Swalwell votes no.
You got one more? Okay.
Mr. Benz? Mr. Benz votes yes.
Clerk will report.
Mr. Chairman, there are 15 ayes and 9 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. That concludes the committee's business for today. The committee is adjourned.
The bill we're not doing.